crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Hello and welcome in to the attorneys. Thank you so much for being with us tonight. An interesting topic of conversation, a great panel of experts and you. So we've got everything we need for a great show. A couple of reminders before we get to our conversation. All throughout the program tonight, you'll see ways you can join the conversation. They're at the bottom of your screen, ways you can call, text, email, whatever works best for you. And a neat thing that Hollis Wright makes available during each and every airing of the attorneys is to make attorneys from Hollis Wright live and standing by and ready to take your call. So you can get in touch with them. That's a free, all fair, and confidential conversation, and it's an opportunity that Hollis Wright makes available all throughout the program tonight. So take advantage of that if a question pops into your mind. Leading our conversation, Carter Clay from Hollis Wright. Good to see you, sir.
Good to see you, David. I hope you're doing well.
Doing very well. Thank you, sir.
Good. Yeah, we've handled this topic in a lot of different ways over the years. We've handled wills and estates, the probate court process, which is the court that oversees the probating of wills and handles a lot of other legal matters as well. But we're going to ask a very direct and pointed question, sort of an attention-getting question here right off the bat, and that is, what happens if I die without a will?
Oh, wow.
Now, it's not the end of the world, but if you die without a will and you have assets or property, which most people have some level or types of assets or property, it is going to create some additional challenges, some difficulties. It's probably going to add a longer amount of time in order to dispose of your assets. So we're going to be talking tonight about why it is such a good idea for people to have a will. Now, you and I are young guys. Kristin, she's a young lady, our guest here tonight. And so impulsively people think, well, I'll do that tomorrow. I'll worry about that later. I'm not dying anytime soon. And that can be a mistake. Because obviously we never know when we may pass away. And if you've got assets and property that you want to leave to your loved ones, it's a good idea to have a will in place. And there's no better person to kind of tackle this subject than attorney Kristin Sullivan, who's joining us for the first time. Kristin, welcome to the show.
Thank you, Carter. Appreciate y'all having me.
Well, we're excited to have you here with us. So tell the viewers a little bit about your background and your legal practice.
Sure. Well, my practice, I tell people I deal with both sides of things, so both sides of the issue of death. And I think it makes me uniquely situated to be able to help people prepare for death and then also to deal with what issues may arise after. So I do estate planning. I help people draft wills and trusts, powers of attorney, healthcare directives, all of those documents that you need to have your plan in place. But I also help families through the probate process afterwards. And sometimes that means litigation. Sometimes that means going to court and fighting out, what's going to happen to a house or a piece of property or a bank account or something like that. And sometimes that just means guiding a family through the process and making sure that everything is distributed how it's supposed to be.
Well, I heard long ago somebody was either on the show or I was talking to them, and the attention-getting question that we ask of what happens if I die without a will is a little bit misleading because, in fact, everybody has a will.
That's right.
It just means if you don't create your own will, the state of Alabama is going to impose a will on you.
You are absolutely right.
And talk a little bit about how that works, and we'll just kind of go from there.
Yeah, so we have a whole set of laws that are in place that guide what exactly is going to happen to your belongings, to your property, to your house, the things that you own, the clothes in your closet, all of those things that you may want distributed to a certain person or family member, or in a lot of cases don't want distributed to a certain person or family member. But we have a whole set of laws that says exactly where those things go if you don't make that determination in your will. So, as you can imagine, the first people it goes to are your spouse and your children. That includes all your children. That may include an estranged spouse.
Yeah.
If you don't have children or you're not married, that could include parents. It could include aunts and uncles and nieces and nephews. And sometimes, as families do, there are people that have more needs than others and less needs than others. And the law doesn't discriminate. The law treats everyone the same. So that's why it's so important to have that will in place to make sure that where you want things to go is where they're going to go.
Yeah, and most people like to control their money and their assets. I've even heard that some people who are in the grave want to continue to be able to control their assets and money.
Absolutely.
But it doesn't work that way. But yes, I mean, I've heard some horror stories about situations where somebody was an estranged spouse, or they separated years ago, but they never got a divorce. And the person who passed away did not have a will. And the children, adult children, thought that they were going to get the money. Dad hadn't been involved. All of a sudden, it comes out that, well, hey, they never got a divorce. The person that died did not have a will. So talk about the problems that can be created there. Talk about how the Alabama statute just deals in bloodlines in terms of how it distributes assets.
That's right. So the specifics of the statute, and I won't get bogged down in all of the details, but yes, the statute doesn't care if you've been estranged from your spouse for 20 years or 30 years, and I've seen that happen. You know, we've seen situations where we've had to pay money into the court because we can't even find the spouse, but we know somebody's out there because there was a marriage and there wasn't a divorce. And we know that the person would have wanted their children to have those things. You know, they would have wanted to provide for their children. It's especially difficult when we have a situation where there are minor children involved who really need, you know, the funds that may be available to them otherwise if the parent had been able to provide for them appropriately. But you're absolutely right. The law cares about legal marriage and bloodlines, and that's it.
For those viewers out there who are thinking, I don't really have any property, I don't really have any money, explain to them why it is still a good idea for them to have a will, because everybody has something. It may just be the clothes on your back, but talk a little bit about bank accounts and just cars, even if they're not a lot of value, what will happen if they die without a will, and why it's good to have a will even for those situations.
Well, a common question that I get is, how much money do I need to have, or what kind of assets do I need to have a will? And what I say is, in Alabama, the age of majority is 19. So you're considered an adult when you turn 19. And when you turn 19, you should get a will. Now, did I have a will when I was 19? I did not. And most 19-year-olds, I presume,
we won't ask you when you actually got a will.
Something about the cobbler and the shoes, yes. But you're absolutely right. Any amount of assets is worth having a will. One of the saddest situations is when someone dies without a will and they have children, because the will doesn't only protect your assets, it protects your children as well. And so if you don't nominate a guardian for your children in your will, then what happens? Who is going to be responsible for the care of your children? The money that's due to them may be tied up in the probate court for years and years and unavailable to them for some of the things that you as a parent would otherwise have provided for. So any amount of assets is enough. If you have money in your bank account, your family is not going to be able to access that bank account as easily or as efficiently if you don't have a will.
Yeah, David, I know we're about to go to a break. When we come back, we'll talk about specific assets and property that are particularly problematic if you die without a will, namely a house, secondary homes. Kristin just mentioned children, minors and things of that nature, how to deal with those situations. So we're going to tackle that when we come back.
Look forward to that. Really important conversation that we're having tonight. Appreciate you being with us along this ride tonight. Just a reminder as we go to break, Hollis Wright is wherever you are on social media. So if you have a Facebook page, a Twitter account, Instagram, YouTube, they are there also. Just search the term Hollis Wright and you'll be able to find them a really great educational, informational, legal resource. Stay tuned. We're coming right back.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching. The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the Attorneys.
Welcome back in to the Attorneys. A really interesting conversation we are having tonight. I appreciate you being with us. Just a reminder, before we get back to the conversation, attorneys from Hollis, Wright are standing by. You've got about right about 20 minutes remaining left to talk with them. They're going to be standing by for the remainder of the show, so take advantage of that opportunity. A free, off-air, and confidential conversation that is yours for the asking. Carter?
Yeah, I want to talk about particular assets in a minute, but I think a lot of the viewers out there would like to know how much is it going to cost for me to have a lawyer draft a will. So what types of costs, assuming they have a fairly minimal amount of assets, it's not a complicated situation, so what kind of cost are we talking about for a fairly boilerplate type will? And then also, what is the time commitment that an individual who would want you to draft a will, like what type of commitment of their time is going to be involved in helping you or assisting you put together a will?
Sure. You know, it's a very typical lawyer answer, but it depends.
Yeah.
It depends. It depends a lot on what your assets are, what you want to do. You know, some people say, this is everything I have and I want it all to go to this one person, and that's a pretty simple proposition most of the time. But I would say, as far as cost goes, you can expect anywhere from a few $100s up into the, a few $1,000s if we're talking about a more complex situation. When children are involved, we may be needing to set up a trust, or you have extremely valuable assets. We may need to do some tax planning there. So there's a very broad range there, but I think that for a lot of people who think it's going to be cost prohibitive, it can be more affordable than you think it will be.
Yeah.
As far as time goes, for me, we usually have a meeting to sit down and kind of get to know each other, talk about what your goals are, what your assets are, how we need to get there. And that takes about an hour, 2 hours maybe. And then we put together your documents. I may have some follow-up questions. We may have a few phone calls to clarify some things. But it's a really small time commitment on the front end as opposed to what could happen on the back end with the expense of court if you don't prepare a will.
Well, let's talk about a family home or just houses in general. So explain to the viewers, why would it be beneficial to have a will to dispose of that type of asset, and what types of problems or difficulties may arise if you own a home, you want to pass it along to certain heirs, but you don't have a will in place?
Sure, we see this problem a lot, and particularly, here in Alabama, it's a huge problem where people pass away without a will, and so then their children, the law says that your heirs at law immediately become, upon your death, the owners of your real property. You don't have to record a deed in the court. Nothing has to be done. You are immediately the owner, or your heirs are. And so, you can imagine if this happens for generations, then, the web becomes bigger and bigger. And so you've got, maybe you have 2 or 3 owners, and then you have 10 or 12 owners. And then, who's responsible for paying the taxes, and who's responsible for the upkeep and paying the bills and the insurance, and who makes decisions about if it's going to be rented or sold or who can live there. So it can really complicate things on the property front especially.
Now, I guess if you pass away with or without a will, what happens to property or houses like that in circumstances where the heirs, say you've got 3 or 4 owners now, they can't agree on who's going to live there? One person says, well, I'm not paying the property taxes or the monthly bills. I mean, is there a liquidation process that would occur? And how does that work in terms of when the property would have to be sold if they can't work it out?
Yeah, absolutely. There is a liquidation process. So the law says that a house can be sold in the probate process for sale or for the payment of debts or for division. So if it cannot be equitably divided, if the heirs can't agree on how it's going to be divided and who gets what, or if payment of debts is necessary, then the house can be sold. The assets are liquidated and the money is distributed to the folks that they are named in the will, or to whoever the law says if they don't have the
And
will.
just to dive a little bit deeper, what happens if like 2 of the people don't want to sell it, but 1 wants to sell it? Like, I mean, I guess does the court just hear arguments from everybody and then make a decision, or is it sort of like majority rules amongst the heirs? If 2 out of the 3 don't want to sell, they don't sell it. How does all that typically work out?
Well, with all of these things, you know, you say, well, you can agree, or we can have a judge agree for you. You know, that's kind of what it comes down to. But yes, you're absolutely right. It's going to go to the court, and the court is going to decide. So you're going to have a third party deciding what happens. And most of the time in those sorts of situations, if you have someone who really strongly wants to keep a piece of property, then the judge is going to say, well, that's fine, but you have to buy out the rest of your siblings.
Can I ask something? How often should you update your will, and how important is that? My wife and I have a will probably 10 years ago. A lot's happened in 10 years. You know, that's a couple of houses ago, and things have changed. Like, how often should you, or is there kind of life circumstances, kind of benchmark life circumstances that should kind of necessitate you updating your will?
Sure. Well, I'll tell a very brief story, but I'll put my own parents on blast here, because I've been practicing law for 16 years now, and they had last updated their will when I was an infant, and I finally convinced them. So I'm going to say more often than they do.
Right.
But you know, I tell people, once you get your will in place, every 2 years is a good time, and we try to send letters out to our clients and say, has anything changed? You know, has anything major happened in your life? Have you gained or lost significant assets? Have we gained or lost family members that or other beneficiaries in your will that we need to update? So about every 2 years. But you're exactly right that big life changes are usually the reasons that people have. You know, someone passes away, or the birth of a child, buy a house, start a business. Those are all reasons that people.
Yeah, and a lot of times, I mean, just from a layperson perspective, I would think that for sure, when you've got your minor children transitioning from being minors into adulthood, if there were things that you put in place when they were minors, for instance, who was going to take care of them if mom and dad passed away, that is now kind of a moot point once they become adults. So that would maybe necessitate an evaluation or reevaluation of the will, and maybe making some changes.
Yeah. I need to update my will. I think that's the lesson here.
I know someone who can help you with that.
I need to get your info. All right, time for us to take our final break of the evening. As we do so, we got one other segment remaining, so just a little bit of time remaining if you want to contact the attorneys from Hollis, Wright. Stay tuned. We're coming right back.
I'm attorney Bobby Bell with Hollis Wright Law Firm. In today's world, social media is all around us. It is common for many people to post on social media regarding their life and activities on a daily basis. Facebook, Instagram, Twitter, and similar social media are a great way to stay connected to others and to share your experiences and thoughts. Some seemingly innocent social media posts, however, can have devastating effects if you're involved in litigation, especially in a personal injury claim, a contested divorce, or a child custody battle. Courts regularly allow adverse parties access to the other side's social media accounts, allowing relevant posts to be presented as evidence. These rules have allowed social media to become a hotbed of information in the litigation world. In fact, we are seeing more and more preservation orders issued by courts requiring you to collect and save any and all social media activity. Therefore, it's advisable that even before there's litigation, lawyers should advise their clients that social media content may be discoverable. Here are a few helpful tips. 1. Do not post anything about the case. This includes posts regarding conversations or meetings with your attorneys. remarks about your injuries, negative remarks about the opposing party. Do not post anything you would not want read in open court to either a judge or jury. 2. Avoid new friend requests from people you do not know. Many law firms and insurance offices may attempt to have employees follow you on social media in an attempt to gain information. 3. Limit adding new photos, check-ins, photo tagging, etc. Seemingly innocent posts may be used against you. Regular check-ins at restaurants, parties, or other events with friends can cast doubt on any claims of loss of enjoyment of life, pain and suffering, or emotional distress, since you appear to be living life as usual. 4. Increase your privacy settings. Many social media sites frequently update and change their privacy settings. In the litigation context, it is possible you may have to preserve and present anything you posted. Therefore, we encourage you to be smart and careful when using social media. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WBTM 13.
Welcome back into The Attorneys. Just about 6.5 minutes remaining in the show. So if you want to take advantage of that opportunity to speak with the attorneys who are standing by from Hollis Wright, you got about 6.5 minutes to do so. Carter?
Yeah, Kristin, I want to talk just briefly to make sure the viewers understand that even if a person has a will or does not have a will, that does not mean that all of their assets will have to flow through the probate court to be disposed of. Are there things that people can do, and can you give some examples of types of assets or property that people can pass directly to beneficiaries without having to have a will, or whether you don't have a will, or going through the probate process?
Yeah, absolutely. So some common examples of these types of assets that you're talking about are life insurance policies, retirement plans. Bank accounts sometimes even have a payable on death beneficiary listed. Or if you jointly own your house, if you own your house with your spouse jointly with rights of survivorship, then your spouse automatically will get the house, or whoever else is listed on the deed. So yes, there are lots of those. One of the problems we see is when people have a life insurance policy or they have a retirement plan in place and they name their children as beneficiaries, but without consulting with an attorney, then what happens to that money? Because your child who is a minor can't receive that money. So even in this situation where you have beneficiaries listed and you have these assets that we say pass outside of probate, it's really important to consult an attorney on how to list those beneficiaries.
Yeah, and sometimes I've seen people that with like life insurance, sometimes they'll put the estate, my estate. Well, then you're basically back to square one now.
That's
because
right.
You haven't listed a beneficiary that's an individual, so it's going to flow through your estate as well. But I think that's important because with respect to like life insurance and houses, you can put them in joint right of survivorship and do some things where it will directly go to the beneficiary and sort of bypass the probate process.
Absolutely.
But for the property that you don't have a designated beneficiary, you don't have it set up in a way to pass directly to the beneficiary, those types of property or assets will go through the probate process.
That's right.
All right. Internet wills. So we all see advertisements on TV or things that pop up on social media, Instagram, Facebook about contact us, we'll put together a will for you. Do you have any experience with those types of, I guess, just sort of boilerplate type wills, and are they good, bad, indifferent?
Yeah, and I hate to be the one selling my own wares here,
sure.
but I'll tell you, I signed up for one of those websites recently because I kept getting these ads on social media about it, and I said, well, let me see how it is. And I gave them all of my information, and what the product they gave back to me was not compliant with Alabama law. And that was a huge red flag to me. I thought, well, no wonder. I have clients who come to me after a loved one dies. Right now, I'm dealing with a case where someone had an internet will and it is just utterly insufficient. And so it is costing the heirs a lot more money and a lot more time because we're having to go to court and have a judge tell us what do we have to do with this?
Because the will didn't even qualify under
That's
Alabama
right.
law. And that, to some extent, I could see how that would happen because these are national companies and they definitely don't have individual lawyers with all of the states out there advising them on the nuanced areas of laws within a particular state, because that's another good point, which is that all of this is controlled by each individual state law. And there are different state laws, obviously, that control this area. So I could see where that would be problematic.
It absolutely is.
All right, we're going to have to wrap up here in a minute, but talk briefly about the probate court process. Sure. What could a viewer or an individual expect if a loved one passes away and they have a will or they don't have a will? Like what type, how long is it going to take to probate assets and distribute those assets through the probate court, and kind of what's involved?
Sure. Well, as we discussed, the process is a lot easier if you do have a will. If you have a will, then we get the family members to sign off on a couple of documents that are really simple. We submit that with a death certificate and with a copy of the will to the probate court, and your executor is able to immediately step in and start doing the work, doing what they need to do under your will. If you don't have a will, the person's going to have to get a bond in place. We may have to have a hearing. There are just a lot of steps. And then when you don't have a will, you also have to go back to the court to ask permission for things like, can I sell the house? Can we have an estate sale for the property? All of these things require court approval if there's not a will there. The process has to last at least 6 months under Alabama law to allow creditors to file claims against the estate. And it can last, we usually say between 6 and 18 months is pretty typical.
We're just about out of time, a minute and a half remaining, but want to give both of you an opportunity for a final thought. And if you would, Kristin, you go first, please.
Sure. My final thought is get a will. Even if you think you don't need a will, you probably do. If you don't, you have it there in case, and it's going to make life a lot easier for your loved ones who are already dealing with a lot of grief after you pass.
Yeah, David, as you can tell, Kristin is very knowledgeable on the subject, but she's also very passionate about it and truly believes that people need to have a will in place. And if nothing else, just talk to somebody like Kristin and evaluate your particular situation and let her explain to you the pros and cons of having a will versus not having a will, and the problems that it can create for your loved ones down the line, the time-consuming process that they may have to go through if they don't have a will. Because I just think consulting with a lawyer on something like this, even if you decide not to get a will, can prove to be invaluable. But I think Kristin would probably convince you pretty quickly that you need to get a will, and it's pretty cost-effective.
Right. And the number, I've never heard anybody complain that man, my loved one who passed was so organized in that will, they regretted that versus the opposite.
Yeah, I haven't seen that happen very often.
There are horror stories out there. So great job. Appreciate you being with us tonight.
Yeah,
Thanks so much for having me.
Really good stuff. Helpful. Appreciate Kristin and Carter being here, and you as well. Some important stuff. For your piece, do it now. For their piece, do it later. It's a right decision for sure. Thanks for being with us. We'll see you next time right here on The Attorneys. Have a great week.
Thanks for watching The Attorneys, sponsored by Hollis Wright.